good afternoon. Thank you for sharing your lunchtime with us. When you registered for the course, some of you indicated some questions that you were interested in ahead of time, and thank you for that. That's good for us because sometimes I have to do a little research to actually answer your questions. The questions that came in this month, they were pretty much general questions that we will be answering in the context of the presentation, which is actually the most effective way for people to learn, to tell you the truth. But it's also great because I know who's on this webinar, and I see the big variety of attendees and employers and interests. So thank you very much. Feel free to promote us with your colleagues. So we're going to begin now at the very beginning, before there's ever an incident, before there's ever an injury or illness or worse. And we're going to talk for a moment about the Labor Management Safety Committee. This is important because it helps create a safer workplace, which is what we all want. Let's avoid an incident in the first place. Well, here's an idea for you. Comes out of the union movement. It's a very established and successful thing. Just create a committee in your workplace with workers and managers. We have some ideas on the screen here for how you might want to do it. You might want to rotate the chair of the committee, but you certainly should be meeting regularly, and you certainly should have an agenda when you meet. And the idea is to talk about the places in the workplace where incidents might happen, or the places in the workplace where incidents do happen. But this is not a workers' comp claim review. This is a real dedication to safety. How can you work more safely? Also, it's not just the places, it's the equipment that you're using. It's the procedures that you're using. Are your employees or your colleagues being trained on the safest possible way to do their jobs? If they're not, well, I would really recommend you create some safe procedures, you document them, and then train everyone on them and hold everyone to that standard. Here's how we do it here. We care about safety. All right, now let's talk about the workers' comp system. I'm going to give this to you from the worker's point of view, but everything I'm saying pertains to the entire system, and we will have some tips for employers and insurance carriers too. Number one, workers' comp is a no-fault insurance system. That means there's an insurance payer behind the claim who's going to actually pay the benefits. Adam and my employer is the Workers' Compensation Board. We do not pay the claims, except in one instance when there's no insurance, but we'll get to that. Employers have to provide this insurance coverage. This is for workers to protect them in case of an on-the-job injury or illness. It also protects the employer because it removes liability from the employer. That's what they call the grand bargain that was struck in 1914. The workers do not contribute directly to the cost of this insurance, so if you're a worker, you will not see a deduction on your pay stub for workers' comp insurance. It is your legal right as a worker, so you can't sign it away. You can't negotiate it away. Don't worry about that. These rights are all set in the law and in practice. The other thing that always pops up, immigration status. Well, here's the rule. Immigration status is not a factor. It's really that simple, ladies and gentlemen. It's just not a factor. It doesn't matter where the worker was born, when the worker arrived in the U.S., it's just not a factor. Also, if a worker does not prefer to speak English or is not fluent or is uncomfortable in English, well, we provide language assistance services. We we, and by that I mean the Workers' Comp Board, we will provide translators if there's a hearing so that the worker can have the proceedings spoken to the worker in the language of the worker's choice. We're not limited in language either. We'll get you whatever language you wish to use. We can translate documents. Also, if you deal with my office, well, Spanish is the second most spoken language in the great state of New York. I have a Spanish-speaking representative. So if you speak Spanish and you need to talk to us in Spanish, we can accommodate you directly. If you speak a different language, we'll get a translator on the line. So here's our employer here, the Workers' Compensation Board. We are a New York State government agency that administers and oversees the system. There are about 1,000 of us. We have 26 offices and hearing points all across the state. We receive the reports of injuries, the reports of payments. We receive all the documents in a workers' comp claim, and then we put it in our claim folder. Every worker has a claim folder for every claim, and each incident is its own claim. So if you're a worker and you got hurt in 2010, you have a claim for that. If you got hurt yesterday, you will have a separate claim file for that one as well. If you're a worker, you really should be using eCase. So this is my little pitch. You come to our website, wcb.ny.gov. Right up at the top, you'll see a button for eCase. If you're a worker and you don't have access to your own claim folder, I'm really recommending right now that you get access to your own claim folder, and then you could see all the documents in your claim folder. The other thing that we do, in addition to storing these documents and looking at them and acting on them, is hold hearings when it's appropriate to move a claim forward, because we do have the system where hearings will occur in front of a law judge, and that those are board staff who adjudicate the claim and then move it forward. We'll talk more about hearings in a little while. The Advocate for Injured Workers. Well, that's me, actually. I'm the manager of the Office of the Advocate for Injured Workers. I'm known as the Advocate. My civil service title is actually Ombudsman, and I'd like to say hello to the other person who signed up for our session today who also has the title of Ombudsman. That's highly unusual. Adam and I are smiling because you're only the third person I've ever heard of who has that title. But an ombudsman is someone who cares about the health of the system. That's me. That's why I report directly to the chair of the board, the head of our agency, and I bring forward system issues. The folks in my office and myself, we also help workers with the most difficult and complex claims. We'll have our contact info up on screen at the end of our presentation today. We're also involved in fatality claims because there is a fatality benefit, and we'll talk about what that benefit is in a little while. And also, I do work directly with the 9/11 community. We have just passed the 21st anniversary of that day, and I would just like to announce right now that the deadline for filing the WTC-12 form was extended another 4 years. So if you were there, if you participated in rescue, recovery, and cleanup for a year after September 11, you really should tell us you were there and file the WTC-12 form, because that will then preserve your right to file a claim should you ever need to. Come to our website, put WTC-12 in the search bar. If you did rescue, recovery, and cleanup, please do this. If you need to talk about this, contact my office as soon as you can. Here's a new topic, but a foundational topic. Who pays your workers' compensation claim? It's going to be a form of insurance that's paying your claim. So there are two ways that employers not workers, but two ways that employers can secure this insurance. The first way is buying an insurance policy through an insurance carrier. There are about 260 different insurance carriers who write workers' comp insurance in New York. That policy is going to pay the benefits. The other way is what's called self-insurance. That means that the employer has set aside money or has the funds available to pay the claim if a claim should arise. That's why it's called self-insurance. Now, a little bit of detail on self-insurance. We have two types of employers. We have public employers and private sector employers. Public employers, those are governments, cities, towns, counties, school districts. Those are all public employers. Public employers in New York State almost always, but not always, but almost always self-insure. That means that they don't have to, but they almost always choose to hire a claim administrator. That means they're hiring someone, some firm, to handle the claims for them. Some of the very biggest self-insurers, like, for example, the City of New York, well, the City of New York is self-insured, but the City of New York has developed an entire office of people whose job is to simply handle the workers' comp insurance. So that's how the publics work. The privates, there are about 115 corporations in New York who are big enough that they're also self-insured. And when I say big enough, I mean when you're a private corporation, you now have to demonstrate to this board that you have the probably millions of dollars of money available to pay comp claims should you need it. These are very, very large corporations, multinational corporations, billion-dollar corporations. It's not Adam's Pizza, okay? But they also tend to hire claim administrators. So what this means, if you're a worker, is if you have a workers' compensation claim, you are not going to be dealing with your employer. You are not going to be dealing with your human resources or personnel department or your supervisor. You're going to be dealing with an insurance company or a claim administrator. Finally, the last bullet on screen there is one instance when the board will make the payments in a claim, and that is an instance when there is no insurance in place. Now, one instance is the volunteer fund, which has to do with volunteers who responded to the World Trade Center, who did not have an employer. There's a little fund set up to pay their claims that we administer. But there's also the instance where an employer should have been carrying insurance and chose not to. Well, that's a violation of the law. And so in that instance, the board will advance the payments to the worker so that the worker is held harmless. That's a little insurance jargon for you. But we don't want the worker to suffer for the employer's malfeasance, so the payments will be made and the board will bill the employer. So this is not something that the worker would have to worry about. The benefits would be provided. But on that topic, we do get this question about independent contractors and who needs coverage. And our advocate for business, I'm Injured Workers, the advocate for business does a monthly webinar where he talks about this at greater length because he's talking to employers. You'll also get Adam on that one. But here's the answer. Who needs coverage? Businesses with employees. If you have employees, you're a for-profit business, you need coverage. Most nonprofits also need the coverage. Okay, so if there are employees, your default thinking should be, do I need insurance? Do I need workers' comp insurance? I have employees. And the answer is probably yes, because, well, Even if you have one part-time employee, you still need the coverage. Now the question becomes, who's an employee? Because we do hear the term independent contractor used a lot today. So there are also questions. We had this question ahead of time. What about remote work? People working remotely? Well, here's the easy answer for remote work. They're still your employees. They're still covered. Okay? Things that happen to them when they're working remotely, if they're related to their employment, it's still workers' comp. But now let's talk about who's an employee. Anyone who's providing a service to a business, and a business is a for-profit business, okay, that individual could be determined to be an employee. Who determines it? Well, ultimately, the Workers' Comp Board determines it. Also, on the nonprofit side, if the entity is, say, a 501c3, well, any person who's compensated might be determined to be an employee. There are some limited exceptions we noted on screen for you, such as clergy or teachers, but other than that, yes, that compensated person could be an employee. Now, let's talk about independent contractors for one moment because it's such a popular topic. Internet businesses, let's talk about that for a moment. Please remember, just because a worker is an independent contractor for tax purposes does not mean that the worker is an independent contractor for workers' comp purposes. Why is that? Because every government entity is operating under its laws, the laws that pertain to that entity. And in workers' comp, we have a workers' comp law. That's what this board administers. Well, we're going to use the definition for independent contractor that fits under the comp law. And that definition comes down to the issue of direction and control. Is the potential employer exercising direction and control over the worker's activities? Now, that might be different than what the tax law says that the New York State Department of Taxation and Finance operates under and the federal IRS operates under. And that might be different even than what the New York State Department of Labor operates under and the Federal Department of Labor. We all have our own laws to operate under. Those are 5 different laws I just covered. So the point is, you could be an independent contractor for tax purposes, but not for workers' comp purposes. And remember, if there's a dispute, if there's a question, when it comes to comp, it's the board who's going to resolve it. You should also know that a number of internet businesses, such as the popular ride-sharing options, well, guess what? They're carrying workers' comp insurance. So just because you're getting paid by an internet business, that doesn't mean you're an independent contractor just because somebody said so. If you get hurt, file a claim, let us sort it out. What do you do if there's an injury? Well, here's what you should do. Number 1, get the necessary medical treatment promptly. You just got hurt at work? You don't have to go to the urgent care that somebody else says you have to go to. You go and you get the medical care where it's appropriate. You can choose it, especially if it's urgent, especially if it's emergent, as they say. Number 2, you got your medical care? Well, you need to tell your employer that it happened because we have to start the chain of events that now leads to a claim, you see. So, you're the worker, you went and got your medical care. You should tell your employer in writing as soon as possible that there was an incident. It's only right, it's only fair, and you have to do that because now the employer has to tell its insurance company. And if you're an employer and you're listening to me right now, someone tells you there was an incident, tell your insurance company right now. Don't do it next week. Don't do it next month. Don't do it when you get back from vacation. Do it now. there are people from insurance companies listening right now who are cheering, I'm sure. Because when I do this in public and I see your faces, they always cheer. Because it's important, because the insurance company now has an obligation to tell the board that there was an incident, or they can get a penalty. They also have an obligation to begin making payments within a certain time frame, within 18 days, or they can get a penalty, and they don't want the penalty. Also, if you're going to do it in writing, you should do it in writing. If you're going to do it in writing, please send a document or an email. Yes, you are allowed to text. I just don't recommend you text because you know how hard it is to go back in a scroll and find a particular text if you should ever need to prove it. Then you're a worker, file a claim form. File a C3. Come to the website, click worker, click file a claim, file the claim. Please file it online if you can. If you have to do it by paper, you can. You print the paper, fill it in by hand, and mail it in. But if you can do it online, please do it online, because then we can actually read it so much easier. And it's faster. It's cleaner. You have 2 years after incident to file a claim. Everyone always asks this question. But it's 2 years after the incident to file the claim. So that's why I say do it as soon as possible. And then continue receiving any necessary medical care. We want you better. And now, a word from Adam.
Thank you, Joe. We have a new feature today we're introducing to you guys. We're going to open up a poll, which I'm going to do right now. I'm going to read the scenario on the screen to you, and we want your input here, yes or no. Should Kadir file a workers' compensation claim? So Kadir is not an American citizen. He is in the United States on a work visa. He works 40 hours a week on site at a software company at a desk using the company's equipment. The desk was provided to him by the company, and he works on tasks that the company assigns him. He works 8 hours a day, though his start and end times do vary, and he works on a 1099, so the software firm considers him to be an independent contractor. One day, Kadir is inattentive, and he drops a computer server. It winds up injuring his left leg. The employer calls an ambulance that winds up taking Kadir to the hospital. So when Kadir gets to the hospital and gets his retreatment, should he do it under a workers' comp claim? Yes or no? Just put your answer right in the poll. I see we have some answers coming in already. Lots of yeses. We have 71% say yes, it looks like. I'm sorry, I'm reading this wrong, but we have a lot of yeses. The majority are yeses. Joe, what do we think?
Oh, well, it's telling us that the percentage of people on here are saying yes. We don't have any. Do we have one no?
We have one no and 50 yeses.
Okay. Well, the answer is yes. Kadir should go ahead and file that claim. It happened at work. We put a bunch of red herrings in there. He's not an American citizen. Doesn't matter, remember? Doesn't matter. The software company considers an independent contractor. Well, that's between Kadir and the company, but that's not relevant in workers' comp. What's relevant in workers' comp is the insurance company directing and controlling his activities, and we gave you enough clues in there to indicate that, yeah, they probably are. He was inattentive, and he dropped the server on his leg. He was inattentive. Well, remember I said it's a no-fault insurance system? It's a no-fault insurance system. Maybe you should pay more attention, but the fact that he was inattentive is not going to kill his claim. So we're not saying Kadir is going to get the benefits, but we certainly would recommend that Kadir go ahead and file a claim and make his employer aware of this. Now we're going to talk about the benefits of workers' comp. There's a medical benefit, there's a lost wage benefit, there's also a fatality benefit. We'll do that one last. First, the medical benefit. Our mothers were right. We should get medical care and take care of ourselves. I'm looking at Adam while I say this. That medical care in workers' comp is available at no cost to the worker. At no cost to the worker. Also, it is a lifetime benefit. So that means once you have an established claim for an injury, you can receive medical benefits for that claim for life. This is where I have to do something a little bit difficult, so I'm sorry ahead of time. But if you're from an insurance payer, please do not tell your injured workers their claims are closed when their claims are not. The only reason I'm doing this is because several times a month, a worker reports to us that that's exactly what an adjuster said. No, the only time a claim is closed is when there's a settlement agreement via Section 32 or the old school lump sum agreements. That's the only time a claim is closed, ladies and gentlemen, and we all should know that if we're professionals here. So it is a lifetime benefit. You got hurt 10 years ago, you hurt your leg 10 years ago, yesterday you woke up and it's seized up and you can't move, go to the doctor. Give them the WCB claim number, give the doctor the insurance claim number, go to the doctor and get the care. It's a lifetime benefit. And this includes all the medical expenses, office visits and surgeries and hospitals and physical therapy and equipment and so forth. The other thing workers don't always know is that the transportation costs to and from medical appointments are reimbursable. You would fill in a Form C-257, which you can get off our website, and you're going to put to and from. I started at home, I went to Dr. Marshall's office, and then I drove back home. You put down the mileage each way. If you took public transportation, what did that cost you? If you took an Uber or a cab, what did that cost you? You might want to save a receipt too. And you submit that to the insurance company for reimbursement, and you can go back in time. There's no time limit on these requests for reimbursement. Here's a best practice. I was just hinting at this a moment ago. When you go to the medical appointment, you're going to tell the provider that this is workers' comp or it's work-related or it happened at work, depending on when you go. Maybe you just got injured. You say, yeah, it just happened at work. Okay, but once you have a claim, please arrive with your board case number, WCB case number. See the bullets on screen? The insurance company is also going to give it a case number. Give the provider that also, and give the provider the name of the insurance company, okay? Because the provider has to file the CMS 1500 and the medical report. Okay, if you're a provider and you're listening to me, you're sending in a CMS 1500 and you're sending in the medical report with the key questions answered. Disability, work status, causality, and you're sending it to both the insurance company and the board. That'll get you paid, and that will also help the claim move forward. Also, if you're on temporary benefits and you're a worker, you need to see your doctor every 90 days, okay, or your provider. You need to see the provider every 90 days because the provider has to give an opinion on how disabled you are. That's called a degree of disability. That's the second bullet. That is key. So providers, you need to file that percentage, temporary impairment. And workers, you should understand that 100% temporary impairment, 100% degree of disability, that means the provider doesn't think you can work. You could also get a 75% or a 50 or a 25%. You could really get any number percentage, but those are the numbers that tend to be used. And that impacts your level of benefit. We'll talk about that in a moment. Here's another best practice. You're a worker. You may be asked to attend an independent medical exam. These are called IMEs in our system because our system loves acronyms. I don't, but our system does, so I should tell you about them. So if you're asked to go to an independent medical exam, workers, you should understand a couple of things. Number one, that doctor, and it's almost always going to be a doctor who's seeing you, that doctor is not treating you. There is no doctor-patient relationship in this exam because it's truly just an exam. This doctor has been hired by the insurance payer to give an opinion about your condition. Maybe how disabled you are, maybe how much loss you've used, but they're hired to give an opinion. So they're not going to give you treatment recommendations. They're not going to tell you what to do to get better. That's not why they're there. You may, if you wish, bring a witness to your independent medical exam. Even in the time of COVID, no, the IMEs cannot tell you you can't bring a witness. If that happens, you contact my office. You may also record the IME. Cell phones are very popular, I understand, these days. They seem to have cameras in them that record audio. Your witness can do that. Yes, your witness can record this IME. They can't tell you that you can't. You're also going to get an IME report afterwards. I'm going to urge you to read that report and make sure that whatever the report says happened is on that video. Now, there might be some medical things that are happening that you don't understand, that you can't tell were happening. Yeah, sure, we understand that. But you want to read the report. You want to make sure everything that's stated in the report is, to the best of your knowledge, did happen and did happen the way it says. If you have discrepancies, you should tell your attorney if you have one. You can tell my office as well. If you see a big discrepancy, like the report says that you were given this test and you did not get this test, you need to tell us about that. You need to tell my office because I receive complaints about IME conduct. Now, I said the word conduct, okay? And I'm not talking about disagreements. Your doctor says you're 100% disabled. The IME says you can go back to work tomorrow. That's not conduct. That's a difference of opinion. That's going to have to be litigated. But when I say conduct, I mean, were you treated in a civil manner? Was the exam conducted in a medical type facility? Okay, we had one infamous instance where a fellow in a wheelchair was asked to come to this building for the second time that was not handicapped accessible. The wheelchair did not fit into the exam rooms, so he was given an exam in the waiting room. That's no good. That's no bueno. So if these things happen, you should contact my office and we'll talk to you. You may also claim the travel reimbursement to and from that exam on Form C-257, the way I was saying about your regular medical care. This is also eligible. Let's switch over now to the cash benefit. In the industry, this is known as indemnity. All right, so you can't work. Now you're going to be eligible for the indemnity benefit, and there's a calculation that happens. You would be eligible for 2/3 of your average weekly wage. Now, number one, it's 2/3 because this is all tax-free. There's no tax on a workers' comp benefit. Number two is we're talking about an average weekly wage. That means in order to calculate what you're going to get, we, the board, we double check or we make a finding. But the insurance company, first off, will get your wages for the previous 52 weeks. Okay, there's a 1-year look back, and whatever you earned in the previous 52 weeks, that's your basis, all compensation counts. So if you got overtime, that counts. You got a bonus, that counts. You have 2 jobs, you need to tell us about your second job. Because if you can't work one job, you can't work the other job. So it's all compensation, even if you get non-monetary compensation. Maybe you get housing. Okay? You need to tell us about that because housing has a value. So that goes into your basis, and then you can get up to 2/3 of that amount if you're 100% disabled. The maximum right now is on screen. That adjusts every July the 1st. That's based on the average payroll in the entire state of New York. So as that changes every July 1st, this changes as well. All benefits are temporary unless you have a permanent problem or injury, I should say. The doctors will decide when you're permanent, and then it'll come to the board and we'll make a finding saying it's permanent. But while it's temporary, you need to see that doctor every 90 days. Also, if you should come to the point where you suffer the loss of use of a limb, the fourth bullet down, that's called a scheduled loss of use. That means, let's say you injured your arm or even your shoulder, but your arm is now not 100%. Well, there's a benefit available for that loss of use. There's also occupational hearing loss, there's vision loss, and there's facial scarring. These are some of the other benefits that are available. Finally, here's a little note to workers. Please, when you file your claim, or if you ever have to deal with the board, please note where you were working. Okay, New York City, Buffalo, these are big cities, these are big places, and sometimes people go to a construction job or some sort of a site job, and they're not quite sure what the address was, where they got hurt. Please know where you're working. Please get the address where your incident happened. Because if you're doing, say, construction, well, we can pull the building permit for that address, and then we know everything. We know who the insurance company is. We know who the employer is. It just makes everything so much easier. Here's another best practice. Payments. We're talking about those indemnity payments. Please consider using direct deposit. Please. Some of us fought very hard to make it a mandatory option. I have no idea why you would get a paper check in the year 2022. So I'm just going to leave that at that. But if you're getting paid in cash, that's fine. Cash is still, cash is king according to Adam. But also cash is still the currency. It's fine if you got paid in cash, but you need to keep a record of what you got paid. I'm suggesting everybody get a notebook or open up a computer file. Please note how much you got paid, when you got paid, who paid you, what you got paid for doing. Because frequently in these cash situations, nobody has a record. Everybody's making estimates and guesses. But if you show up with actual documentation, well, that's probably going to be very helpful. The other benefit is the fatality benefit. If a worker is killed or dies due to employment, here's how the benefit works. There is a funeral or memorial expense reimbursement. The amount is up to $12,500 in the New York metro area. So New York City, Long Island, Westchester, Rockland. The rest of the state, it's $10,500. The surviving family can receive the indemnity benefits calculated the same way the lost wage benefit is, but there's a bit of a hierarchy, so I'd just like to show you. First, we look for a spouse, a lawfully, legally wed spouse. Gender is not a factor. And then if there's no spouse or if there are children of the deceased, and that includes adopted children of the deceased, they can receive the benefit until they're 18 years old or until they're 23 if they're attending higher education. This also includes disabled dependents of the deceased and blind dependents of the deceased. Disabled and blind can receive the benefit for life. If none of these parties exist, $50,000 is payable to the parents of the deceased. If none of these parties exist, $50,000 is payable to the estate. That means there's going to be an executor in the mix, going to be filing the papers. We're going to send the papers out from my office. You will get a mailing from us. We will help you with this. If there's a distant family member who I did not name here, you know, Auntie Jen, Cousin Mel, well, they're going to have to deal with the executor. They are not going to receive the benefit directly if they're not in this hierarchy I just named. Finally, the last bullet. There is an organization named Kids Chance. It is a national nonprofit that has a chapter in every state, including New York. We are not affiliated with them in any way. However, Kids Chance provides scholarships to the children of workers who perished due to employment or who were grievously injured. So their web address is on screen, kcnewyork.org. I would say if this is you or someone you know, go to the website and fill in an application because Kids Chance is asking for applications for these scholarships. Finally, we're not wrapping up, but just to end this train of thought, COVID claims. COVID is an infectious disease. Infectious diseases are payable in the New York workers' comp system. There are a couple of special things you should know, though. Here they are. Number one, in a COVID claim, the medical report is going to be key. So there's probably a positive PCR test somewhere. Find it and file it. If you got your COVID diagnosis, there's no PCR test, but you have a diagnosis by a provider saying you had COVID, you file that. I'm sorry, this is an insurance-based system. We do not use home tests in this system. I'm sorry, it's really that's the answer on that one. You have to have a PCR test or a provider making a diagnosis. You talk to the provider, the question is going to be, where'd you get COVID? If you got it at work, well, that makes it a workers' comp claim. So you want to talk to your provider and you want to include when you file details like, did you have public contact? Did you wear a mask? Was the public wearing masks? Is COVID-19 prevalent in your workplace? Do your coworkers have it? Do your customers or clients have it? You can get COVID from a coworker, and it happens in the workplace. You now have a workers' comp claim. We have a fact sheet and a short video available on the website about this topic. If you think you got COVID in the workplace, I don't care if you got the paid sick leave. I don't care if you had a really good result and you're feeling great right now. You should file the claim because we just don't know what's going to happen in the future. And remember I said workers' comp is a lifetime benefit for medical care? You might need that one day in the future. You know, I hope you don't, but let's just protect ourselves. Now, Adam has something to say on the same topic.
I do. We have another poll. 1 second here. I can pull it up. So just same as last time, just yes or no. We'll get your answer here. Should Liz file a claim for COVID-19 exposure? So Liz worked at a big box store in the seasonal department during the holidays where she dealt with the public. One day, Liz felt ill and called in sick to work. She took a PCR test for COVID and it came back positive. She did receive her paid sick leave for the 2 weeks of work that she missed. And during the time, she was very vigilant about following COVID protocols. She wore her mask. She social distanced. She did not want to go home and bring COVID to Cousin Mel or Auntie Jen. And several of Liz's coworkers also had COVID at the same time. So knowing all that, should Liz file a claim for COVID exposure at the workplace? And let's see, the results are coming in. For this, Joe, we have another slew of yeses, majority yeses. Yeah. What do we think?
Well, number one, I really like the way this poll works. You guys should see what we see. It's really great. We have these little bar graphs. But number two is yes, Liz should file the claim. Of course she should. We've given you a number of indicators on screen that it possibly would have happened at work. So that's why we say file the claim. That's why we don't say she's going to get the benefit. Yeah, she should file the claim. And we even put in the paid sick leave there. Yes, okay, so she got paid sick leave. Here's what happens. If you got paid sick leave for COVID, you file the claim And if workers' comp, if it gets established in workers' comp, if you would have been eligible for an indemnity benefit and you got the paid sick leave, the insurance companies will talk to each other and they will make each other whole, okay? It's not something the workers need to be concerned about. The insurance companies know how to do this. There are penalties for late payment. So if you're an insurance carrier, you want to make those payments on time. And I'm happy to report that in 90% of cases, the benefits are being paid on time. So congratulations and thank you for that. We're talking about 18 days from incident or 10 days from notice, whichever is later. Yeah, the first benefit check should be going out. Also, if there's a decision from one of our judges, that benefit should be paid within 10 days of the filing date of that decision. So if you're a worker and you're wondering about this, you get a decision, look at the bottom right of the piece of paper that we send you, the document we send you with the notice of decision. There'll be a filing date. If you're getting a paper check, it should be postmarked 10 days from that filing date. If it's not, contact your lawyer, contact us. You could be due a penalty. And also, interest is due in some circumstances after an appeal. So if you're an insurance company and you appeal the benefit payment and the appeal came back and said, no, you really should be paying this benefit, you might be responsible for paying some interest to the person whose benefit was delayed. So don't forget about that. Workers have some responsibilities in this system as well. Try to come back to work as soon as you're physically capable, okay? All the studies show the quicker you can come back to work, the quicker you can safely and healthfully come back to work, the better your outcome's probably going to be. The employer might have transitional duty available, alternative duty, light duty. Enlightened employers will certainly do this because you could have somebody with a low level of a disability who could do something a little different from the regular task. So if you're an enlightened employer, bring the worker back. Get the worker back in the fold. The recovery is better, and guess what? You're not paying the workers' comp benefit any longer. That lowers the pressure on your premiums. Also, if you're a worker and the board sends you something, pay attention to it. If we ask you to do something from the board now, please do it. And if you move, please tell everybody your new address. Oh my gosh, yes, I've moved too. I know some things slip through the cracks, but please try and stay on top of that one. And if you make any agreements or you have a representative, ask questions of your representative. If you make any agreements, understand what you're signing. Understand what you're doing here. Stay involved with your claim. Don't let things happen around you. You might have a hearing. Okay, we're getting towards the end here. You might have a hearing in front of our law judges. If you're an injured worker, you may hire an attorney. That is certainly permitted, and sometimes getting an attorney is a very good idea. The insurance company is definitely going to have an attorney at that hearing. So you can get an attorney or a licensed claim rep. We have that list on our website. And you're going to appear before a law judge here at the board who's going to make findings of fact. There might be witnesses if you have what we call a trial. There might be some depositions from witnesses or especially doctors. The board does not use the formal rules of evidence and procedure that courts use. That's because we're not a court, actually. It's not like Law and Order. There's no robe, there's no gavel, but everyone is treated respectfully and civilly, and all the parties at the hearing should be behaving respectfully and civilly like they would in a court. And there will be formal findings made by our law judges. How are you going to do these hearings? Well, during the pandemic, we're closed to the public, so we have what are called virtual hearings. But guess what? Because we have virtual hearings, we didn't miss any hearings when the pandemic hit either. So what we're saying here is we have a way to essentially teleconference a hearing. It's called a virtual hearing. We have an app if you want to download it from Apple or Google. Or when you get when the hearing is scheduled, you will get a hearing notice. The hearing notice will say there are two ways you can attend this hearing. One is the virtual hearing, and we'll give you a code, and you can either go to the web URL that's given, or you can go into your app and you put in your code, and you go into the waiting room, you're in. The judge will bring you on when it's time. The other way is that if you can't do that, but you can telephone in, well, there'll be directions on the hearing notice. The thing is, you need to tell us before the day of the hearing or at 8:30 a.m., and I'm serious, at 8:30 a.m., you need to tell us you want to attend by phone and give us the number where the judge can call you, because the judge calls you. Your lawyer doesn't call you. You don't call in someplace. The judge calls you. That's for security, and that's to make sure everything is legitimate. So definitely stay involved in your claim. There's our URL in green there, wcb.ny.gov. We have so much information on our website, it's not funny. Sign up for e-case. Sign up for e-case. If you have an attorney, ask your attorney your questions, and your attorney can actually give you legal advice. I can't. Your attorney can, or your legal representative can. Here's a tip for reaching your legal representative, because we get this question all the time. You call the office, you might get a paralegal or another professional, because attorneys really do attend hearings all day long. Ask that person your question. If it turns out that you need to actually speak to your counselor, well, leave a time by when you're willing to take a call. For example, if you're willing to take a call at 7 p.m. or 8 p.m., tell them that, because the good ones will call you back. If you're going to ask your employer a bunch of workers' comp questions, you could give your employer a break. They're probably not going to have the most current information. It's probably not what they do. But you can ask the workers' comp board. We can and will give you the correct information. We also put in a new computer system, a business information system named Onboard. It's fully phased in for the first release. It is being used by the insurers and by the healthcare providers, and it does work. It works way better than what we used to have, and my personal favorite element of it is that there are no more paper forms, so I don't have to try and read someone's handwriting any longer. Here are the social media contact points for our agency. YouTube, guess what? We have over 100 videos available on YouTube, including a recording of this, including recordings of previous sessions, including recordings of our provider sessions and our onboard sessions and all of our other sessions. You want to catch up on something, go to YouTube, and it's right there. And then I think that we will probably leave this up while we do your questions.
Why are auto insurance companies and or their employers not required to inform injured people of their coverage? This worker had an auto accident and was not aware that he was covered for workers' comp.
All right. This is a pretty broad question. I cannot answer the auto insurance element because that's not what I do. I'm not trained for that, I'm sorry to say. But I can answer this question in the context of, let's say you're a worker and you are on the job, on the clock, and you are driving, and there's an accident. Yes, you have yourself there a probable workers' comp claim. You should file it. You have workers' comp claim because you were working when you got injured. What's the time limit for filing that? 2 years. That's the kind of thing that we can't really overstate. You have 2 years to file a claim. Why are the auto insurance and companies and employers required to inform workers of coverage? No. Well, okay, here's the thing. Employers are responsible for telling their insurance company about an incident. The insurance company is responsible for now filing a claim. So guess what, worker? You're now going to get notice that a claim has been filed, and you'll get it pretty quickly. So that's the notice that you're getting. Your employer should be telling you the name of their insurance company. They should be. If they're not, employers, why wouldn't you do that? It's not like the person's not going to file a claim, because they can just call us and we'll say the name of the insurance company. Also, every employer has to have the, I think it's the 105 poster is what it's called. Every employer has to have a poster hanging up in a common accessible area that does list who the insurance company is for workers' comp. You also have to display it for paid family leave, and you also have to display it for disability benefits. You get that from your insurance carrier. You don't get it from us. If you don't have one, call your insurance carrier, ask for it, and put it up, because you could be cited for not having it up.
All right, thank you, Joe. Next question. Some employees belong to a New York office but work remotely from a different state. If those employees come to New York to work for a few times a year, which state would the employees be able to claim workers' comp? Would it be in New York or the state that they reside?
It would be with the insurance company that the employer has purchased the policy from. So if the employer is domiciled in New York, well, you should use the New York system, and you should use that policy that the employer has purchased. One other thing, by the way, if you are a multi-state employer, you need to have New York specifically listed on your policy for your New York people. We do not use what's called an all states endorsement. You have to have New York listed. That's for the employers.
All right. Before we get to the next question, I do see a couple people asking where if they can get a copy of today's presentation. If you go to our YouTube page, as Joe had mentioned, you will see a recorded version of this presentation that you can share with your other employees if you'd like. It's also available on our website if you search for the Advocate for Injured Workers. It's right, there's a link to the recording right on that page as well. And we do update these recordings as recently as we can, so we try to keep it up to date. All right, next question, Joe. If a workers' comp check from the insurance company is returned due to insufficient funds, what should the worker do to get their money?
Well, this is a highly unusual but potentially in the offing question. It's highly unusual that an insurance company would issue a check that was returned insufficient funds, but it can happen. Number one is, I would definitely, if I were you, I'd go right back to that adjuster and say, hey, what the heck is going on here? And you should get your check reissued. Number two is, you need to tell us about it. You can tell us here at the Workers' Comp Board, you can tell my office about it, because this is the kind of thing that we do need to know about. And the big reason is that every once in a great while, an insurance company can run into some financial troubles. We have a backstop available for that. It's called the New York State Liquidation Bureau. We have this backstop that will pick up the payments of the claims if the insurance company should go bankrupt or have some other sort of insolvency issue. So we need to know about that, because it might be our first notice of a problem, and then the board will work with the Liquidation Bureau to bring them in to get them to take over the payments of claims. So definitely tell us. And if that has happened, I expect to be hearing from someone this afternoon.
All righty. So we have a question about the new onboard system, Joe. So if a worker suffers a hand injury in New York, they improve and then move to Florida. But later on, once they move to Florida, they want to see a hand specialist in Florida for further treatment. And they're having a difficult time finding a provider in Florida who can access the medical portal for onboard. Is there a workaround in onboard for out-of-state providers? And if not, what should they do?
I think all providers have to use Onboard.
If an out-of-state provider is treating a New York workers' comp patient, they have to be registered for Onboard. You can email, I don't want to give an email address because I'm not sure what the email address is, but if you go to wcb.ny.gov/onboard, you can find more information on the provider section, and that'll allow you to that'll guide you to where you need to go and who you need to contact to register for the medical portal.
Thank you, Adam.
You're welcome. Let's see, where we got next?
Best practice.
What is considered the best practice for employers when it comes to informing staff of their access to and rights for workers' comp?
Wow. This person gets a gold star for asking that question. Okay, best practice, number one, you could have the workers take this webinar. Number two, you can come to our website and you could go to the bottom of the page on our website and look in that nice pretty green bar and you'll see publications. You click it and we have over a dozen publications devoted to workers. We also have publications devoted to employers, and we have a bunch of other materials there which are helpful to everyone, including providers. Number three, an employer could create a labor management safety committee, the first thing we talked about. That's going to be helpful. I would urge you to do that. And number four, you can have a staff meeting. You know, the people can all talk to each other, which I'm a big fan of that. And you talk to each other and the employer can simply say, okay, if there's a work-related incident, here's what you should do. And remember early on we had that slide. You get medical care, you tell your employer, you file a C3, you keep getting your medical care. You can refer to that. That's in our publications also. And you can also make your employees aware that, number one, there's an insurance company that's actually going to pay your claim. It's not us. We're going to probably be pretty much out of it. Well, if there's a claim, the insurance company will handle it. But here's the name of our insurance company. And if you do get hurt on the job, here's how we would like you to report it. You might have an incident reporting system. Well, we would recommend you use that.
All right. If someone is injured in a car accident driving to work, is that considered workers' comp?
You're asking presumably about commuting. If you're commuting to and from the job, it's probably not payable in workers' comp. The exception would be, let's say you were called in unexpectedly to work. Let's say your employer reached out to you and said, you know, Dr. Schweitzer, we need you to return to the hospital right now. Okay, if you had an accident at that point, well, you could file a claim at that point.
All right, so a question for our YouTube page name. If you just go to youtube.com and search for the New York State Workers' Compensation Board, you should be able to find it that way. But I do believe the actual page is youtube.com/New York State Workers' Compensation Board, all one word. All right, so should an employee file a C3 form if the employer is paying medical expenses through first aid as they lost no more than 1 day of work due to an injury?
We have to clarify this question a little bit, Adam. But let's do that. Let's talk about the idea of first aid, and let's talk about how injured you have to be to rise to the level of workers' compensation. The threshold in the law is that if a worker receives more than the equivalent of 2 first aid treatments, you're in the workers' comp realm now. So if a worker sees a healthcare provider, unless that provider indicates I rendered first aid, well, now you have a comp claim. So this worker is saying, employer is paying medical expenses through first aid. Well, number one, I'm sorry to say, I don't know what that means. I don't know what it means to pay medical expenses through first aid. So I'm going to have to address it in terms of first aid. And first aid is a Band-Aid or the equivalent. So I don't know what paying the medical expenses through first aid means. But if there are medical expenses, well, that says to me that we probably have a comp claim here. That employer should be telling its insurance company. That worker, if there are medical expenses being incurred, you go on ahead and file a C3, and we will sort it out for you. If the worker lost a day of work due to injury, well, that makes me think that maybe we have a workers' comp claim here, yeah.
All right. So can an injured worker go to any medical provider, or do they have to be an authorized provider to treat workers' comp patients?
We definitely have authorized workers' comp providers. You definitely should be using them. If there's an emergency, you can see any licensed provider. So if you don't have an emergency and you don't see the authorized provider, well, you still can get the benefits, yes. But you should be using that authorized provider list, please.
Okay, and if an employer offers If an employer offers a disability policy, should the employee file that along with workers' comp, or just should they only file for workers' comp?
I'm glad this question was asked because it gives me a moment to expand a little bit. If an employer has a comp policy, that employer better have a disability policy too, and a paid family leave policy, which is part of disability. Because the thresholds for carrying all these different insurances, I think they're identical, or they're so very close that it would be an exception. It would be a big exception if you carry comp and not disability. Now, let's talk about disability, because that is a different type of insurance, but this agency also administers disability and paid family leave. Paid family leave and disability are on the same insurance policy, by the way. Okay, we're talking about the statutory disability, the mandatory disability policy. Employers can buy extended disability. They can buy long-term disability insurance, AFLAC and so forth, Metropolitan, long-term insurance. But we're talking about the short-term disability, the 26 weeks that pays no more than $170 a week. No, you can't have short-term disability and comp simultaneously. That's because comp is on the job and disability is off the job. Your injury or illness happened off the job. However, let's say you do get hurt at work, and let's say the insurance company disputes your claim or controverts it. That's the technical term, Well, in that instance, you're maintaining that you had an on-the-job injury, but you're not getting paid. You're going to have some hearings. You're not going to be having any money. Yes, you can file for the disability benefit during this period of time. I would recommend you do that immediately because there's only a 26-week period for this. And then if your comp claim is not established or disallowed, well, there you go. You qualified for disability and you got paid already. But if your comp policy claim is established, well, you're going to tell the insurance company about the disability payments, and the two insurance companies will talk to each other. The two insurance companies will exchange funds. The worker will be out of that equation. However, I just want to make sure the workers have some income, some money coming in for this period when they're not getting paid.
All right, we have a few more questions that came in, then we're going to wrap it up here. How come some companies do not want employees filing workers' comp claims?
Boy, really put me on the spot, Adam. Okay, so let's assume that there is a company that does not want workers to file a comp claim. Well, I don't want it to rain when I go to the ball game either, but there's nothing I can do about it. So if you're an employer and you don't want your employees to file a comp claim, just file that away somewhere and don't say anything because you'd be actually breaking the law. Now, why would you not want them to file? Well, because when employers sometimes worry about their insurance premiums, and so that's why they might not be crazy about a comp claim, but there are two legitimate reasons why an employer should keep his or her mouth closed and not do that. Number one is it's unlawful, and number two, it's rather inhumane.
All right. And what can you do about retaliation for employees filing a workers' comp claim?
Oh boy. Well, it is the same person asking both of these difficult questions. Okay. Yeah, I'm sorry that this does sometimes happen. There is a process. We have a discrimination claim. It's known as the DC 120. D for discrimination, C for claim 120. If you're a worker and you feel that you've been discriminated against for filing a workers' comp claim or retaliated for filing, well, fill in this claim and you're going to have a hearing here. We have special hearing parts devoted to discrimination, claims. You'll have your hearing. A judge will make a decision. The judge does have the authority to award you back your position. The judge also has the authority to award you your back pay. The judges do not award, big payments for penalties and so forth. It's not like civil court. But yes, you can certainly file that claim.
All right. And if there's a settlement, does the injured worker have any recourse? The settlement was a lump sum that included costs for all future medical care.
All right. We're going to wrap up with an explanation of Section 32 waiver agreements. Notice I changed our terminology. People use the word settlement and they use it casually and incorrectly, so let's just be precise because it's worth it. In the workers' comp system, the two parties, the worker and the insurer, they can come to an agreement to permanently close a claim. That's called a Section 32 or a Section 32 waiver agreement. There are two sides to the claim. There's the medical care and there's the lost wages. You may settle one side or both sides. If you are a worker, you do not have to do this. Some parties might pressure you to do it or speak highly of it. If you want to do it, go on ahead. You do not have to do this. Also, you should know the board cannot compel either party to do this. So if you want to close your claim and take a Section 32, please don't contact us and ask us to talk to the insurance company for you because we can't. You are going to get a payment for the lost wages if you close that. You'll get a payment today. And you can use that payment however you want. Best of luck. If you close the medical care, you're going to get a payment, and you're going to have to put it in a special account and only pay for your medical care with that money. You cannot go out and buy a Corvette with that money. You have to use it for your medical care. When it's gone, well, I would just encourage you workers to think, how am I going to pay for my medical care when this money is gone? The question was, does a worker have any recourse after a settlement? If you left the system, you left the system. I'm sorry, but that's the way it goes. You close both sides of your claim, you left the system, that's that.
All right. And that is all the time we have today. So again, thank you for joining us. Thank you for asking some great questions. Thank you to Joe for taking the time to give this presentation and answer the questions. Just a reminder before we sign off, as part of the Advocate for Injured Workers series, this webinar will continue to be offered in the coming months. So if you need a refresher at any point, or if any of your colleagues couldn't join today, there will be other opportunities, and you can find a list of our webinar dates for this series, as well as a variety of other webinars we host at the board's website, wcb.ny.gov, and then scroll down to the bottom of the page, there's a webinar section. and then you can sign up there, or most of our webinars actually don't require registration, so you can just join the day of and be good to go. This next presentation will be given on October 19th. And again, if you need a refresher before then, I encourage you to go to YouTube and find the latest recorded version of this presentation we have. You can also sign up to receive workers' compensation news, including information on future webinars, straight to your inbox. To sign up, visit the Workers' Compensation Board website, scroll down to the bottom of the homepage, and select Get WCB Notifications. As well as YouTube, we do also distribute information on our other social media channels, so please be sure to follow the Workers' Compensation Board on Facebook, Twitter, and Instagram. Again, thank you all for joining us, and please enjoy the rest of your afternoon.